as Robert said, I'm Mark Joseph. I'm the lawyer at Democracy Fund, along with two other gentlemen, Adam Blake Gallipo and Alan Honor. And I've been given the impossible task of describing legal work without putting you to sleep. So I'm not gonna riff either. Everyone so far has been great at riffing, but lawyers don't riff. So I'm gonna try and not read, but just bear with me. I'm gonna hit the highlights, and then I'm gonna make some observations about practicing law during the pandemic. And finally, I'm gonna mention future threats to civil liberties. So it's hard to adequately describe the stupidity and Kafkaesque legal situation during the pandemic. We had a student at a Canadian university who attended an affiliated campus overseas. The university had a vax mandate for its Canadian campus. Despite the fact that our client would never actually attend campus in Canada, the university insisted that she get vaxxed or be expelled. In our demand letter, I actually had to write the line, "It is well known that biological viruses do not spread digitally." Of course, we also represented dozens of folks charged in connection with peacefully protesting in Windsor and Ottawa at the Freedom Convoy. Perhaps you'll recall several gentlemen charged with providing jerry cans of fuel to truckers. Well, we represented them. Interestingly, it's not a crime to carry a jerry can of fuel in public. Otherwise, we'd all be charged if we refueled our jet skis or snowmobiles. But interestingly, nonetheless, the Crown charged our client with mischief, okay? So as we're trying to figure out how the charge of mischief applies here, it occurs to us that the Crown has no evidence about the contents of the jerry cans, right? How does the Crown know the jerry cans contain fuel rather than, say, water? Well, it turns out that the Crown didn't know. The cops had no record of the contents of the jerry cans. So I'm not saying that there were fuel in the cans, and I'm not saying that fuel went into the police motor pool and then to the police vehicles. I'm just saying that the Crown couldn't say where the fuel ended up. So we got the charges dropped. We had a Freedom Convoy client who was alleged to have blocked access to the Ambassador Bridge. This was in Windsor, obviously. The Crown sought 45 days in jail. They're always seeking 45 days in jail or thereabouts. Turns out our client was arrested in a Canadian Tire parking lot. Okay? Can anyone see the problem here? You've got the Canadian Tire parking lot and you've got the Ambassador Bridge over here. So there's a big space between those two locations. So there was no blocking of anything, basically, except for the Canadian Tire parking lot. But anyways, it took 2 years of court appearances and a judicial pretrial before the Crown withdrew the charges. Okay, so this official stupidity was often only rivaled by official cruelty. For example, we had a client who was charged with failure to complete the ArriveCan app. She was driving to the US to receive experimental cancer treatment. Her young daughter went with her. Upon return, she failed to present the right COVID test, and she was ticketed $6,000. And her daughter, $300, okay? The Crown threatened to go to trial. Mom then died of cancer. The Crown did not immediately drop the ticket, then suggested that we provide proof of death. My TDF co-counsel, Adam Blake Gallipo, who's out in the hall, you can say hi to him, he appeared in court advising that the Crown was seeking proof of death, and said we had no instructions or intention to seek that from the child. Only then did the Crown withdraw the ticket. Another client traveled to the US with his elderly diabetic mother for a brief visit. His mother forgot her insulin, so they returned to Canada. The border agent tells him to go get a PCR test in the US or he'd be fined $6,000. So driving back and forth to get the test would have taken more than 24 hours, at which point his mother might suffer hyperglycemia. Client took the ticket rather than risk his mother's survival. We confronted the Crown with this tricky choice and convinced them to drop the ticket. All told, TDF and its team of lawyers and paralegals, Jenna Little is an excellent paralegal that handled stuff in the background. We handled about 2,500 pandemic tickets. and saved Canadians millions in dollars in potential fines. We represented dozens of Freedom Convoy protesters criminally charged with offenses ranging from mischief to breach of court order to resisting arrest. Many of those charges were dismissed, and the ones that were not, only one resulted in anything more than a conditional discharge, and that is under appeal. We are helping Tamara Leach through her excellent lawyer, Lawrence Greenspan, of course. We represented the Coots 3 in Alberta, as well as Pastor Pawlowski, Pastor Reimer for, Pawlowski. Pastor Reimer for peacefully protesting in a public, peacefully praying in a public building, and pastors, many pastors who kept their places of worship open when ordered to close. We got the Ontario College of Teachers to successfully conclude their investigation of Chanel Fall. She was an Ontario teacher accused of challenging DEI. So yes, TDF held the line as best we could. Now some observations. So the pandemic, if anyone cared to notice, was accompanied by legal contradiction and hypocrisy. Protests that were identical in form were prohibited or allowed depending on the content. For example, BLM protests were allowed, but protests against the lockdowns were not. Some religious buildings were targeted, some were left alone. Small merchants were forced to close, but large establishments were allowed to open. Important government officials, this is my favorite, could travel freely, but we, the plebs, could not. COVID changes apparently depending on the person it infects, I don't know. None of these seemingly contradictory policy positions were justified by medical science. We were just told that we either complied or we would be fined, arrested, or charmingly sent to a camp. In almost all cases, when the issue of scientific basis for a policy was raised by a lawyer, the courts simply deferred to government experts or took judicial notice of otherwise complex medical evidence. Often during the pandemic, fundamental legal principles were ignored. I'll give you an example. So the rule of law requires that laws be published. You might have heard Bruce Party mention it's called prospectivity. Why? Because if people don't know the law, they can't properly guide their conduct in reference to it. But during the pandemic, governments were making and changing laws weekly through a legal instrument called orders in council. I didn't even know about these things, but they could be issued without the need to consult lawmakers or administrative regulators, right? They were fast. So the problem was that the laws were changed so quickly that citizens did not or could not know the state of the law at any one given time. So we had clients who were charged with breaking a law that was not published until days after the offense date, which is bizarre. But probably the worst case of this concerned ArriveCAN again, and this was discovered by Alan Honor, our litigation director. This is a little bizarre, so try and understand what's going on here, because lawyers had difficulty with this. But the law allows the government to set conditions. The law that allows the government to set conditions for entry into Canada is contained in the Quarantine Act. Okay, so that's the big act that was in play. So sometime in November of 2020, remember that date, the government issued an order in council which said, a person who enters Canada must provide their suitable quarantine plan or their contact info by electronic means specified by the Minister of Health. That was November 2020. Notice anything? It doesn't mention ArriveCAN as a specified electronic means. So how did the public know what an electronic means to use? Well, our political masters eventually got around to specifying ArriveCAN as the electronic means, but they buried it deep in a bureaucratic landfill so that no one would notice, an obscure website for archived public health declarations, where we find a declaration, another date, November 26, 2021, in which the government specified ArriveCAN as the electronic means. November 20th, 2020, November 26, 2021. So thus, prior to November 26, 2021, it looks like the government had not actually published a law establishing that you had to use ArriveCAN. Is this a problem? Well, it turns out it is. Quite a big one, in fact, because it's been a principle of law since the Code of Hammurabi in 1750 BCE, that people should know the applicable laws. Like even our children's coloring book of a charter sets out in section 11G, a person has the right not to be found guilty on account of any act or omission unless at the time of the act or omission it constituted an offense under Canadian law. Okay? When we confronted the managing Crown with this argument, she said, well, everyone knew they had to use a ArriveCan. How? Like from the town crier? Like, you know, like did you get a handbell and a feathered cap and yell, hear ye or something? Like, you know, it's called the town crier argument we used anyways. I mean, Moses came down from the mountain with stone tablets so that everyone knew the deal, right? Like even God is bound by this basic rule, but not the Canadian government during COVID, apparently. So, needless to say, the Crown quietly dropped all of our tickets dated prior to November 26, 2021. So, of course, the best recent example of junking the rule of law was the invocation of the public order emergency. A quick review of the legal grounds for invoking a public order emergency under the CSIS Act was enough to establish that without serious cross-country real or threatened violence, the government would not be justified in declaring an emergency. And anyone at the Freedom Convoy in Ottawa or Windsor knew that there was no actual or threatened violence. So the emergency invocation was unreasonable, which was a view TDF espoused when we participated at the Public Order Emergency Commission. So you might have seen the recent decision by Justice Mosley, which held that the invocation was unreasonable. So we were not surprised. But for my part, I think that Justice Mosley's decision is thorough and well written, but we'll see what the Court of Appeal does with it. So the issue that bedevils civil liberties lawyers is that our charter is not terribly effective at protecting civil liberties. It's like going into combat against the armored knight of state authority with a pool noodle. No, it is. All right, let me anticipate new dangers to civil liberties. So Bruce Pardy has ably explained the mortal threat to that Bill C-63 represents to our freedom. Ezra Levant has done that as well. We all understand the necessity of free speech. I'll just note that every new offense in Bill C-63 is already covered by existing laws. So essentially, Bill C-63 is a Trojan horse that will release into Canadian society an army of bureaucrats and informers empowered to crush dissent. But Bill 63, by creating a vast bureaucracy to regulate online content, also creates a superstructure that will allow governments to further restrict civil liberties later. Those restrictions, I predict, will concern not just hate's the wedge, it'll concern misinformation and disinformation. Because the ability to censor your political opponents for mis or disinformation is like the Ark of the Covenant for governments. They will smite their enemies before them using it. It's like, you know, Indiana Jones with the ark and the lasers coming out. Like that's what it's going to look like. In November 2023, the Director General of UNESCO, United Nations Educational, Scientific, and Cultural Organizations, put out a statement that read, "Digital technology has enabled immense progress on freedom of speech, but social media platforms also accelerated and amplified the spread of false information and hate speech." Notice that they twin those two terms, right? Posing major risks to societal cohesion, peace, and stability. To protect access to information, we must regulate these platforms without delay, while at the same time protecting freedom of expression and human rights. Okay, so you know when you eat ice cream and you get an ice cream headache? That part where they say, to protect access to information, we must censor it, gives me an ice cream headache. It doesn't make sense. So TDF wrote to UNESCO and asked for a meeting after we read this. That's kind of odd. So during the meeting, we confronted UNESCO about their support for censorship. Now, I'm going to pause here and explain the philosophical problem with censoring mis and disinformation. So you can use this to impress your friends at parties or get yourself thrown out depending on the crowd. But just hang on one second. So one, for at least 2,400 years since the pre-Socratics, philosophers have struggled with a theory of knowledge. So what does it mean to say that a statement is true? Well, you're welcome to think about this in your own time, but I'm telling you, it's not an easy question to answer. To this day, no one has figured it out. So there's no philosophical foundation upon which to base a ministry of truth. None. Treat anyone who claims otherwise with contempt. 2, we have no practical tools that can definitively, unfailingly differentiate moral and political truth from falsehood. The best we have developed so far is the scientific method, and that only deals with scientific knowledge, which rather than comprising a set of unassailable beliefs, is under constant revision. All right? So now back to the UNESCO meeting. We asked about these problems. The UNESCO representative had no answer. They just claimed that no, they weren't seeking to regulate speech. They flatly denied it. That's what we're dealing with. Note that nonsensical government positions won't stop governments from attempting to regulate speech using the pretense of harm from disinformation and hate speech. Okay? Doesn't have to be coherent for them to do it. And once government assumes the role of arbiter of truth, our status as free people ends. We are done. So from everything I've read over the past 5 to 10 years, it seems our political class wants to establish the panopticon of English philosopher Jeremy Bentham. That's the one central tower looking out into open prison cells, arranged in a ring. That's their plan for us. So that's the fight TDF will be facing in 2024 and beyond. Your social media posts and public comments will be subject to government scrutiny and censorship, supercharged by East German Stasi-like informants. Proponents of censorship often retort that this can be all handled humanely and rationally once we appoint the right censors. Right? It should be obvious by now that this is comically mistaken. But let me make a few additional comments on it. One, there's a brilliant quote by the late William F. Buckley Jr., where he said, "I would rather be governed by the first 2,000 people in the Boston telephone book than the entire faculty of Harvard." That's basically my religion. I mean, that's as close to religion as I get. But this is the core assumption behind the Anglo-American political tradition. And it's been repeatedly vindicated because every expert the government proposes as a truth-telling prophet turns out to be false. People who claim moral superiority in ascertaining moral and political truths are frauds. It's obvious to anyone familiar with recent history that the government is in fact the biggest purveyor of mis and disinformation. The government's real concern is not in regulating mis and disinformation, it's in maintaining their monopoly on spreading it. The beauty and tragedy of our social and political life is that we're all left with our imperfect human powers of discernment. No one person or organization has any supernatural critical faculties in this regard. So what does all this mean for journalism? Well, independent journalistic outfits such as Rebel are actual, not fake combatants in this war against mis and disinformation because they remain among the last group of reporters free from government influence. Many, if not all, establishment journalists, this will probably be familiar, are intentionally incurious and do not ask difficult but important questions, mostly due to the fact that the government is paying them for their silence and credulity. Everyone has a bias, okay? But people will pay for reporting which is informative and at least partially usefully reflective of the world rather than being blindly ideological. Adversarial, skeptical reporting is not only healthy for individuals, but it's necessary for a functional liberal democracy because new information leads to adjustments and corrections in government policy. Now, if you've been paying attention, though, you might guess why governments oppose free speech. Free speech may cause citizens to elect people who change government policy. Well, while it may be good for citizens, it's bad for anyone dependent on the political status quo. So we need independent journalists to identify social and political problems that need solving, just like we need organizations like TDF to rectify these problems. We all have a part to play in this fight, And if you want to support us, go to TDF_can on Twitter or donate at thedemocracyfund.ca.
The only reason I'm able to provide free legal assistance to Canadians in their fight for civil liberties is because of your generous donations to the Democracy Fund. If you like what we do, please consider making a tax-deductible charitable donation today at thedemocracyfund.ca.